Thank you for joining us in this discussion. We're going to be talking about mortgage lenders' equitable remedies for breach of fiduciary duty and breach of trust. Before we do that, can we just introduce ourselves? I'm Jeremy Cousins. I'm a Chancery Silk from 11 Stone Buildings in Lincoln's Inn, and I'm joined by my two colleagues who will tell you about themselves and a little bit about the work they do.
Hello, my name is James Barnard. I'm a commercial litigator at 11 Stone Buildings. A great part of my practice involves banking litigation, and in the context of this talk, that includes claims by lenders against professionals, in particular solicitors and valuers.
And hello, I'm Gary Lidington. I'm another barrister at 11 Stone Buildings. My practice ranges across commercial litigation, property work and professional negligence, and in the context of that I do a fair amount of work for lenders in the situations that we're going to be talking about today.
The problem that we're going to be talking about this morning is what kinds of remedies are available to mortgage lenders who are disappointed when they advance money intending that it be secured on property, and they find after the money has been released either that they have got no security at all for their money, or that they haven't got the security that they hoped for. Quite often what happens in this situation is that the loss which they suffer is not simply capable of being identified as one where no security at all has been obtained. The loss might take the form of the property which they have got their charge on being worth much less than they had hoped for. Now, this could happen because the property market has fallen, or it could happen because the property was overvalued in the first place. If they bring a claim against the solicitors who acted in the transaction, they're quite likely to be met with an argument that the error on the part of the solicitors was trivial and hasn't really caused the loss, or they might be met with an argument that the lenders themselves helped to bring about the loss by imprudent lending. In other words, they can be faced with an argument of contributory negligence. It isn't at all unusual for the two lines of defence that I've just mentioned to be run into one. Also, there may be arguments about whether the mortgage lender has taken proper steps to mitigate loss. I think that the first thing that we need to look at in this situation is, why are we troubling with equitable remedies at all? There are quite obviously potentially claims open to the disappointed lender in breach of contract, breach of retainer, or in negligence. So why bother with looking to equity to provide a solution?
I think that's a very good question that you've asked, Jeremy, because of course we all know that most claims against professionals are framed on the basis of a breach of the retainer or on the basis of negligence because of a breach of duty to exercise reasonable care and skill. So why bother with equitable claims at all? And I think that the reason is, as Lord Millett makes clear in the case of Bristol and West and Mothew, when you're dealing with equitable claims, there are remedies which are peculiar to the equitable jurisdiction. And those remedies are primarily restitutionary and restorative rather than compensatory. And so this means that there is a potential, and I must highlight the word potential, but there is a potential to claim the full amount of the loss, so that issues like contributory negligence, which you've just referred to, can be irrelevant. As you say, we're all too familiar in negligence claims by lenders against solicitors, where it's alleged that they were imprudent because of a high loan-to-value ratio, that they didn't carry out sufficient due diligence on behalf of the borrower. I mean, a case I'm involved in at the moment, the other side have asked for disclosure of the lending file and the lending criteria, and obviously they're going to allege that somehow that is going to affect the solicitor's liability to the lender. or they say that the lender advanced too much money because the valuation was too high. So all those arguments come into play. Now, whilst liability isn't unlimited in an equitable claim, questions of foreseeability of loss, remoteness of damage, and possibly causation don't apply in the way that they do in common law claims, although a claimant still has to show that the loss would not have occurred but for the breach. I think Lord Brown-Wilkinson put it very well in a case called Target Holdings and Redfern, where he said in the context of equitable compensation for breach of trust, thus the common law rules of remoteness and damage and causation do not apply. However, there does have to be some causal connection between the breach of trust and the loss to the trust estate for which compensation is payable, viz. The fact that the loss would not have occurred but for the breach. So I think basically what I'm saying is that you might be able to recover more money.
Now, of course, when we're talking about causal connection, we've got a very recent case indeed that we'll want to talk about later on, but we'll come back to that. But what are the kinds of causes of action that we would be looking to rely upon in the context of equitable remedies?
Well, Jeremy, plainly it's no good simply saying equitable claims are better or give you more options than common law claims if you don't really understand properly what equitable claims may be available in your particular situation. And what's important in this context is to remember that there are two types of claim that may be advanced, and they actually arise in very different circumstances. That's not to say, of course, that there aren't cases in which both will arise, but it's equally likely and perhaps more likely that there'll be cases in which only one or the other will be appropriate as a claim which you might be able to bring in alternative to common law claims.